go ahead and get started now. Make sure everything's on. We're good? All right. Okay, well, this session this morning is going to be about preparing for online dispute resolution. So just by a show of hands, do any of you already have some component of online dispute resolution happening in your court, or is it just something you're interested in and kind of want to learn a little more about? You have a little bit going already, or okay. Anyone else? Okay, well, good. All right, well, we'll go through some of the things to kind of get you started thinking about things that you need to do in order to be ready for it once you're there, so that it's not a whole lot of work right at the very end, or at least at the time whenever you're starting. So just to get started, my name is Jamie Gillespie, and I've been with Tyler for a little over 19 years. I started when I was 10, so that's the only joke I have during this whole presentation. So I am a certified mediator, so kind of understand the components of the mediation process and how that really should fit into the online dispute resolution world. And during my time at Tyler, I've done a number of different things, but one of those is that I've implemented quite a few case management systems, both statewide, county-wide, or anything in between there. So just kind of a little bit of history about me. At the end, we'll hopefully have time for questions, but if not, we do have a booth in the exhibit hall, so feel free to come by and ask more questions, and we'll be happy to answer those. So just want to get started with what the current definition is of ODR. So according to NCSC, the current definition is a public-facing digital space in which parties can convene to resolve their disputes or cases. But there has to be three key components that are part of that. So the first one is it needs to be exclusively online. Kind of makes sense with ODR, right? The O part of that. The next one is it needs to be designed to assist litigants resolve their disputes. So really it's not necessarily there for them to just have conversations, but it needs to help drive to a resolution, okay? And then the last piece is that it needs to be hosted or at least supported by the judicial branch. So it needs to be something that is in support of processes and procedures that you all have, and not something just a third-party vendor has available that could help parties. So that's really the current definition that we have right now of ODR. So what we are going to talk about real quick is we're going to do just kind of 4 steps. And so I've broken these out here, what those 4 steps are. So we'll do case type planning and just kind of the different components that are about the case type and how we want to kind of think through those. Then we'll talk a little bit about your stakeholders and what information that you need to start thinking about and talking to your stakeholders about. We will go into some awareness campaigns and just some of the things that are important to get other people aware of what's happening and changing within the court. And then we'll end it on how to define success and kind of understand what you need to start doing in preparation for any kind of go live, so that you're prepared to actually define your metrics and understand what those mean. So the first thing, our case type planning. So you can see here, we have quite a few different types of cases listed here, but this really isn't an exclusive list. There could be additional types, based on maybe a local rule that your court has some special processes or procedures that you do that could be added in here. But really anything where there's some kind of activity back and forth between the parties to help come to a resolution would work for this scenario for online dispute resolution. And what you want to think about as you're thinking about your case types and how to start is a couple things. The first one, obviously, this is your first one. There's going to be plenty more, so don't think that once you do this one, you can't expand to something else. But really, you need to kind of take a step back and think about where are you going to have the most support from your judicial staff, from your attorneys, from other kind of people that are related to a particular type of case that you have. And also, where is the court hurting, right? So what are the case types that you have that you need to see an impact on? So do you have a really big backlog of your small claims cases? Do you happen to have a large load of modifications for custody cases that come in after a divorce is final? Anything like that, you want to kind of think through to help figure out what do you want your first case type to be, because you want to get a lot of bang for your buck out of the first one so you can really show all the benefits and the impact that it's had on your court. So you got to think through that to kind of get started. So when you're looking for your case type, kind of take a step back and go case type by case type and understand what would be those benefits with each one of those case types as you start to plan out how you want to get started. The next thing we want to talk about is really your integration. So I'm going to show you what we would expect the integration process to be here, and then we'll talk about just some different options that you have. So right here, this is what we see as like the end-all be-all approach to your integration. So the case comes in through the e-filing system. It goes into an electronic queue for the court to review and accept. Once it's accepted, it goes into the case management system. Once the case management system has it, it goes into, or it allows the clerk to come in and add an event or some kind of activity onto the case that then sends it to ODR. Now that's something that could be done automatically, or if your case management system allows that, or it could be manually case by case. But then once that happens, it should go to the ODR system. And then really all of that process that's happening in ODR should stay in the ODR system, because we want to keep in mind that this is an extension of the dispute resolution process, and that is confidential, and we want to honor those, the confidentiality of that. But we still need to have some level of back and forth with the case management system, just so you understand a little bit about what's going on. So if it's, if you're a court clerk, you can kind of see without finding out who a mediator is or really going in and digging into a particular case, you could kind of see what the statuses are and have a little bit of information that's happening. So when we have this ODR status updates, it's not the specific information of what they're negotiating or what resolution they came to. It's really more about what are they engaged in this process? Have they brought in a mediator to participate? Or did they just decide they're not going to participate in this at all? But just so you can understand where it is, and maybe what's the deadline on this, so that we understand when we're going to have that case back into the court. And then the last thing that you can see on the integration is that we want to take whatever the resolution is and be able to file that back within the court, right? As we're continuing to add additional technology to make the courts better, the last thing that we want to do is add additional work for the staff in order to incorporate that technology. So anything that we can do to help bring that and automate as much of it as possible is obviously your best result. So this is kind of our goal here. But you are going to have some situations where you might need a manual process. Maybe you are changing a case management system. Maybe you don't have the integration process defined yet that you want. So, this is kind of what that would look like. So you would have the clerk enter that data into the into the ODR system manually. So they're going to go in there, and the amount of information that needs to be added is fairly minimal to get the process started. You really need what type of case it is, the case number, the parties on the case, and kind of their contact information, and everything else outside of that the system should be able to handle without having the clerks do that. But then once a resolution comes, you're going to need a process for what do I do with that resolution? How do I then process that back into the case management system to close hearings or close out the case or do any of the ending processes that you already have. And so then the integration model, similar to what we showed here, but sometimes you might have some level of maybe a partial integration. So maybe you're not doing the full integration per se that we have up here, but maybe you are integrated with your e-filing system. So once your outcome happens, then that is being filed back through it. Or maybe you only have the part where your case management system is sending it to ODR, and then you need a process to get that document back into your case management system after you have a resolution. So these are kind of what your options are. So you need to think about, based on your case management system, your e-filing system, what do you want or what are you expecting? And this may be a phased process, right? You may say, hey, for phase one, we're willing to do some level of the manual process, but by the time we add our second case type or our third case type, we really need to make sure that we're integrated from end to end, and we're able to do this so that we're not, again, adding the work to our staff to have to do. Okay? So the next thing to think about is your party notifications, all right? So I've put up here, and obviously this scenario is more for any kind of civil or family suit. It doesn't really pertain necessarily to like your traffic and parking and stuff. But so in this scenario, if you have both a plaintiff and a plaintiff attorney, or defendant and defense attorney, or any kind of collection of these people, depending on how that may work, then it's going to be a different scenario on how we want to notify them. So let's take the scenario first of just having the parties. Both parties are self-represented, okay? So obviously that's pretty easy, right? We're going to notify the parties, get them engaged, whether it's through email or even maybe text communication, whatever it is. But when you add in those additional parties, that's where you need to really understand what you want your process to be, think through what your procedures are and your legal requirements to how you can notify them, who can sign on behalf of what party and all of that. So if you have a situation where you have an attorney for all the parties that are engaged, do you want the attorneys to be the one that get notified and they do the negotiation instead of it being the parties? Or do you maybe want a situation where everyone is notified and they all are in there engaging in this process? That's something that might suit your workflow better. And also, I didn't say this, but keep in mind what you define for your small claims could be completely different than the processes that you may want for your family. They don't all have to be the exact same from every single case type. You have the option to kind of make it work based on the rules and procedures that you have for that particular case type. So in this scenario, we have everyone engaged. But what if we have a process where instead we have the attorneys that are actually doing the negotiation, but the plaintiffs and the defendant can get in there and see what's happening, but they just can't make any updates. So maybe they have view-only access, okay? Or even maybe it's the other way around where the attorneys have view-only access. So again, just kind of think through in this scenario, if you kind of took out ODR and put that to the side, how does that work today? So if they're in mediation, if you have mandatory mediation and they're in that process and they come to the court and then they're sitting outside having a meeting with the mediator, how is that interaction happening? And who ultimately is in control of it? And how does that process, how would that fit into an online scenario? So you have quite a few different ways that this process could work. Okay, so the next thing we need to think about are our timelines. So I'm going to walk through just kind of a normal case timeline. Again, this may be a little bit different for your case type or your court, but we have a case that's filed. We have an answer. We have our hearing set, and again, we're putting it out here because we've got some time in between. And this is right here is where we encourage our customers to really put in that ODR process, in between where you have your hearing set and you actually have the hearing that's going to be held. You have this time where there's not a lot of activity that's happening, so allow them to do that negotiation, but go ahead and set your hearing, because if you don't, and then you give them 30 days to do that, by the time you set it, now you may have delayed their hearing by 30 days. And really, one of the key goals of ODR is to shorten that time to disposition, not elongate it, right? So we want to do whatever we can to either keep it where it is or at least make it shorter here. And then you have your final orders. So things to think about when it comes to your timelines is how long before this hearing do you stop the process? Do you allow them this entire time? So let's just say this is a 60-day window. Do you give them full 60 days to do it? And if so, what happens if they come to a resolution at 10 p.m. the night before court? Can you handle a process where they are not in there and you know that they're not because they've come to a resolution? Or do you maybe need to give yourself 5 days or 2 days or whatever it is? But think about, if we have this hearing, how much before that do we need to stop the process? And again, you could do it all the way up until the hearing. It's up to you based on, your procedures. If you're able to handle those coming in and closing out that case before court, then that's gives you a little bit more time, which would ultimately usually come up with more resolutions. How long does each party have to get engaged? Do we want to give them 5 days to start the process? Do we want to give them 7 days? Does it need to be only business days, or do we want to think about even the weekends as the days that we're counting. And one of the things about this that we'll talk about towards the end is that we do surveys at the end of online dispute resolution in our product, and this is actually some really good feedback that we've gotten from the users, is to say, hey, we didn't have enough time. And if we had a little bit more, we think we could have come to a resolution. So we've used that to kind of extend some of the timelines to work with our jurisdictions to say, hey, 3 business days just wasn't enough for them. They're going to need a little bit more. So keep in mind that as you come to these ideas and as you have your plan in place, that your plan could be completely changed based on the feedback that you get from the parties that are starting to use the system and using it in a real life scenario. How long do we allow them to just work just between the 2 parties before we either automatically bring in a third party neutral, or that we allow them to request that? And maybe some jurisdictions are thinking, hey, I only want to allow party to party, or maybe even the opposite, and I don't want to allow any party to party. I only want to allow this process with a mediator. So those are things that you need to kind of start thinking about and understanding, and talking to maybe some of your mediators that help in your court. And then the last one is kind of the same thing, but how long does the mediator have? So do we want to allow them, a week or 2 weeks or even longer to negotiate back and forth with the parties and to help them come to a settlement? So these are all things that you need to think of as you're coming up with kind of your timelines. And again, make sure you remember that what you come up with for like your family timeline may be completely different than what you come up with on small claims cases. And we actually kind of expect that. And just because a neighboring court maybe came up with a certain timeline for their cases, your court is completely different. Even though y'all run on the same rules, somehow we end up with things that are completely different. So keep in mind that you could have something that just doesn't match what they have for whatever reason. Okay, so the next thing that we need to think about as we're talking about our cases is, how is this going to be funded? What are the funding options here? So let's start with the first one. Whoops. Okay. All right. So the court-funded model here. So obviously the pros to this is you're going to have your highest participation, right? Because the parties are going to say, hey, I might as well try it. It doesn't cost me anything. If nothing happens, then at least I tried, right? So you're definitely going to see your highest engagement there. Obviously the problem is it's going to require either, some level of budgeting for you, or maybe even legislative changes to get that money. So that's obviously a con to kind of the entry of using that option. But then you have an option where you have one party paying. So in this scenario, we're saying the plaintiff. And obviously the pros to that is that you don't need to worry about a budget cycle. You don't need to worry about that. It's just another offering that you are providing as the court. And in most scenarios, or a lot of scenarios, this option is a lower cost than them having to go to the court to do work, whether it means that they're spending less time with their attorneys, whether it means that they're having to take off work, pay for parking, get sitters for their kids, whatever it is that they're doing. In most scenarios, using something like this is still going to be less costly than actually going to the court. But it does reduce participation, right? They don't know, what are the benefits of me doing this? What would be the impact if I am able to go through this process successfully? Or what happens if I'm not successful? Did I just waste that time and that money? So that's kind of one of the things to think about with that scenario. And then the last one that we see is where it's actually split between the parties. So you have each party kind of paying some of that fee. So in theory, that makes a lot of sense, right? Because we want to make it even for everyone. But let's kind of look at it like from a small claims case as a defendant. In the event that I really did whatever it is and really owe the person the money, if I'm being asked for this to pay for this, and it's going to make the case resolve faster, and I'm going to have to pay that money out more quickly, I don't really have a big incentive to participate in this process, right? So if it's a voluntary approach, you're not going to get a whole lot of participation when you split the money between the parties. Now, if it's mandated that they have to use this, that's different. But so kind of think about it there. So again, it's the same pros that we had on the plaintiff paying. You don't have to have the court funding, and you will most likely have lower costs than what they would have if they engaged in the entire court process. But this is what we see right now as our lowest participation models when they're split like that. And then I think this is the last one in this section, but the outcome document. So once they come to some kind of resolution, what do you want to pass back into the case? What kind of information do you want? Do you only want the outcome if the parties come to a complete resolution? In a lot of cases, there's really only one thing that they're trying to decide. So any resolution would be a full resolution. But if you're talking about maybe like the parenting, maybe they're trying to go through 10 different options and maybe they have agreed to 7 of them. Do we want to take those and file that back with the court as a partial settlement? So here's kind of your options. We have the full agreement. So they've come up with, and I use the word settlement agreement, that may be a different term for your court, but basically just some kind of document that lays out that they've agreed, both parties have signed it. Maybe it's closing the case where they could come back and file it if they want, or maybe it actually shows a judgment on there, however that works in your jurisdiction. But so they've come to a resolution that both parties are happy with, they sign it and they're ready to file it. But the other scenario is a mediator's involved. Does that look different than just the regular settlement? And if so, what are the different elements, and making sure you understand those and that we can, generate something like that. Then the partial settlement agreement, again, not all cases will this apply to just because you don't have more than one thing they're negotiating. But in the event that there's multiple things, what happens here? Do you ever want that, or would that just then go to some kind of in-person mediation process, maybe to settle the last few remaining items or remaining topics? And then even the last one, just a non-settlement agreement. So maybe they go through this, maybe they even engage with the mediator and they got nothing, right? They came to no resolution on anything. Do we want to file that back into the court saying, hey, they've tried mediation, they've tried negotiating back and forth with each other, but they were unsuccessful, just so that you have a record of that. So these are kind of what the outcome documents can be. And you don't have to use every one of these, but you might want to, maybe you want to do all of them, but the non-settlement, or, maybe you want, you don't care if it was a mediated settlement agreement or if they did it party to party, it's still an agreement. So it doesn't really matter having, a difference between those. That's fine. But just kind of thinking about what you want those to look like, what information that you want on them, and being prepared to, have that ready, and making sure that whatever you need on there requires or meets any requirements that your jurisdiction may have in order to close it. So that was kind of on the case type side, just kind of thinking through the components of your case type, which one you want to pick. Now we are on to your stakeholder support. Yes?
When the parties mediate online, how do you know that it's actually the plaintiff or the petitioner? So it might be in domestic, it might be the petitioner's partner, which doesn't have any stake in the game and is trying to muddle things.
Sure.
How do you take care of that if you can?
Okay, so the question is, how do you know that the parties actually that are online participating are in fact the parties that they say they are? And the thing with that is that when we're inviting the parties to participate, we engage through an email address that's provided by the court. Now, again, that's not to say someone else can't check their email or they couldn't have sent it to them. We also, in the beginning of the process, we do terms and conditions where they're having to go through and certify that they are, in fact, the person that they say that they are. Most jurisdictions have some kind of processes in place that allow for a scenario where if someone even did that in court, which is possible because most of the time we don't really check IDs or anything in court, so there's some kind of rule or something that would allow us to throw out any kind of judgment like that happened. So we really set up the terms and conditions to make people go through it that says they're who they say they are, they have to accept that and move on, and then just the contact information trying to get to the right person. Does that make sense? Mm-hmm. Any other questions about the case type? Yes.
The model that you showed had the case actually being filed before the ODR process takes place, which means they're going to have to pay a fine. With respect to the payment process, have you had any experience or given any thought to having the ODR piece take place before a filing fee occurs as an incentive to settle so that they don't have to pay what at times is a pretty onerous filing?
Sure. So the question being that right now what I've shown up here is the ODR process kind of after a filing in the middle of the case. What happens if we try to do it beforehand, before a case is filed? So right now, as Tyler, as we've used Modria, when we've gone around talking to our jurisdictions, a lot of them were a little bit hesitant to do that process right now, just because they kind of worried about what that might mean. If it's from the court, do the parties think that the judgment is actually enforceable, even if the court really had no process in that or no engagement in that whatsoever? But there are some states, and I know Texas is one of them, where they're looking into doing some option where they have kind of a modified filing fee, so they reduce the filing fee down pretty significantly if you're able to settle with this process. And so it does go through the process. It would be before case filed, but you would still pay some modified filing fees. If you come to a resolution, then the judge signs off on that, and it is an agreement that's filed with the court and file stamped, and then they just pay a little bit less. So you really can do it any way that you want. It's just a lot of courts are a little bit concerned right now, as this is new, putting it in front of the filing process. They kind of want to own a little bit more and see how this works. But the tool certainly can do any process. Yes?
I'm thinking it would work fine because in our ADR program, we allow people who probably voluntary to come in for mediation. They want to do it before they file and they have a dispute. And even if it falls apart afterward, still we've got the people talking together and then they'll possibly come to an agreement later. So I think it would still work.
Okay. I have to repeat it because of the live stream. So, so just your comment was that right now in your mediation program, you do already have a scenario where they can come in without ever filing it, do the mediation on their own, and then if it ends up that the resolution falls apart, they could then go into a case filing.
Correct, and I always tell them that if they sign the agreement, if they come to the agreement and they sign it, it's a binding contract
Okay,
at that point.
right. Yeah, so if they do sign it,
By the court, I'm sorry.
that's okay. Okay, so if they sign it, it is a binding contract.
Yes.
Okay. Okay. Any others before we talk about the stakeholder support? This one really is probably one of the most important components of this, because this is where you're going to get your pushback, is with the parties that were kind of moving their cheese, right? No one really likes change. And once we start talking about something that, especially that could potentially, in their eyes, impact their financials, their family's income, whatever it is, they kind of get a little bit scared and a little bit hesitant there. So this is where you really need to think through that process and engage the right people. So the first thing is on the attorneys. I tell people you always have attorneys that are passionate for this access to justice and really see that as part of their duty and responsibility, and finding those people that have that role in the community and that are respected within the community, and getting them on board with this process will help you. And listen to the concerns that they have, because they may have a concern that's a very valid concern that's just not something that you've thought about. So maybe, what they're trying to explain to you is that the process that you've built isn't legal for whatever reason, or has a few holes in it that we need to work through. So just make sure that as we're talking to those parties and getting them engaged in it, that we are not just doing it just because, but we're actually listening to the concerns that they have and validating them on those concerns. Really having them help review the legal process is important. So making sure that, again, we talked about this earlier when we were talking about the party notifications. In the event that we allow the attorneys to negotiate on behalf of the parties, once it's time for the signature to happen, can an attorney sign for a party? In most states, they can't. So thinking about all of those kind of components and allowing the parties to help, or the attorneys to help and feel like they're part of this and they have some kind of responsibility and kind of engagement in it is helpful. And then having them participate in bar meetings. So again, it's not necessarily just the court coming in saying, hey, this is what we're going to do, but having people that are their peers coming in saying, hey, this is a great process, and here's why. And really, when we talk to attorneys, we explain this is not excluding the attorney. There's nothing that says the attorney can't participate in this process. I mean, they are allowed to get into the system and get engaged just as they would if it were in-person mediation, if that's allowed in your jurisdiction. So it's certainly not to try to exclude them. It's try to help the people that may not necessarily have the same ability to be able to afford them, and just to really help the whole justice system process things faster and a little bit easier. So those are some things that we always try to start with when we're talking to the attorneys. But this is the attorneys, and the one I'm going to talk about next, which is your mediators, are really, they will, you will have everything done and they will stop it in its tracks. So getting them engaged in that process earlier is better. And then the last one, the mediators. You know, a lot of times this whole process that we're even talking about doesn't happen at all within the court space. It's completely outside of that today. So while you may think in theory that you understand the whole process, you may not know all the different components because you don't necessarily see the behind the scenes activities. So getting the mediators involved in that, and whoever your mediation program is, whether it's court employees or a nonprofit that supports your court or whoever, getting them engaged to understand what the process they do today is, and really to be able to work that process in some way into the ODR process. And then one of the things that we talk a lot about when we're talking to our mediators is that, you know, right now, most of the time mediators are limited to a geographical area, right? I mean, if you have certain states, and I'm from Texas, if y'all could not hear that in my accent, you know, we have 254 counties, and we have counties that have, you know, 100 people in them. And those counties don't have a plethora of mediators that are just sitting out there waiting to mediate. But they have a metropolitan area within a few hours of them. But are the mediators really, is there an incentive for them to go there? Probably not. But if you have an online tool like this, it really expands the scope of where the mediators could work. So they are not now limited to maybe a driving jurisdiction that they could have gotten to in a day or whatever. It expands their scope of work pretty significantly. And once you kind of talk about that with the mediators, it kind of changes their perspective a little bit of, oh, this may not limit my work, but may actually expand it quite a bit. And then the last thing with the mediators is just kind of getting them to understand and to talk through the timing. We talked about the timelines. How long should we allow them to have? Well, understanding that from the mediator's perspective, and also helping the mediators understand that this process may not be for every mediator. You know, we have mediators that have been mediating for, you know, 30, 40, 50 years that like that engagement with the person face to face. That's perfectly fine. But we may also have mediators that are newer to this, have maybe less time during a normal business day, and would like expanded hours to be able to, to be able to do the mediation, that would love this. And what we have actually seen from our courts that are using this is we have some mediators that their in-person rates are lower than what their online rates are. And then we have some that's the exact opposite. Their in-person rates are much higher than their online. So it's finding the right people to do the work is really what you want to do. So don't think that, you know, if you talk to one person at the mediation center and they're thinking, we're not doing this, there's no way. As you keep kind of engaging with them and getting their buy-in, there are a lot more things that they need to be thinking through than just, you know, the first thing is, oh my gosh, we're no longer relevant, right? So really kind of as you go through this, think about the mediator side for this. And again, and I didn't put it on the slide, but just like what I said with the attorneys, is listen to what they say. Again, most courts don't really engage fully in the mediation process. The judges order it, and it's kind of a separate group. So getting the mediators to explain some of those processes and understand to us is very helpful to make sure that we are you know, doing all the legal requirements and the processes that are important to get to resolution. Okay. All right, we're on to our step 3 now, which is the awareness. So really the most important people that you're trying to get aware of this program is your citizens, right? So You want to think about getting your local newspapers engaged. Maybe there's podcasts that the court puts off. I know in Florida there's a couple podcasts that the courts do, so maybe that's something that you would want to do. Getting a quick little news segment on your local TV. This is an example here of a judge in Williamson County, Texas, and he called it pajama justice because it's 24/7. You can do it from your home. So this was kind of what that news article was. And they did actually a TV segment on it and a news article that was in the Austin American-Statesman. But getting your legal aid offices to understand what this is, why you're doing it. A lot of times these people have engaged in the legal aid process, so they feel comfortable there. And if they're getting the information from legal aid, they understand what it means and how it works, and even your law libraries that you have in the courthouses. And then the last one I put here is some of the nonprofits. So some of the nonprofits that help, whether it's shelters or the churches or anything that kind of help sometimes with people that are going through the legal process. Anytime, the more people that are aware of this, the better your results are going to be because they're going to help encourage that process. If they understand what it is and what the impact could be, they'll really help. So I'm going to show just kind of some examples. So these are ones that we did for Clark County, Nevada, or Las Vegas. They use this for their family program. And I have two different items here. One of them is what we just call a rack card. So it's just a small item that can either go in an envelope that's sent back out to the parties, or it can be handed to them if they come into the office, that just has a little bit of information about what it is, how you're going to be contacted by it, and why you should use it. And then we have these larger posters that are, like 11 by 18 that go in the elevators at the courthouse, and they go in all the courtrooms. And this would be something you would want to put in the law library and the legal aid offices and share it kind of anywhere that you can. So again, as they are to that point in their legal process, they've already heard about it, they're familiar with it, it's not something that's scary to them. And then I kind of put some more stuff here. So again, make sure that the communication that's coming from the system is coming as it's the court. We get so much spam. I don't know about you guys. Maybe I just sign up for too many online shopping sites. But, the amount of email that we get every day that's just junk is pretty high. So if there's not something that's catching their attention that this is a court program, a lot of times they're going to just go right by it, right? They're not going to engage in it at all. So making sure that it's coming from the court and that it is branded to look like it's the court. And then on the court website, that's a great place because that's really where people are going to go if they're getting some kind of communication that they think maybe is from the court or maybe not, is going to that court website and having some kind of banner on there that really explains what this process is, when they'll hear about it, all of that. So these are the kind of things that you need to do for awareness, and you really need to focus on the awareness with the citizens, because those are going to be the people that are going to have probably the most questions about the process and really kind of be standoffish, because you've already gotten your mediators engaged, you've gotten your attorneys engaged, so this is really where you're going to focus that. Any questions there? All right, we're on to our last one, which is our measuring success here. So, every court has different reasons why they want to do something like this. So thinking about from your court's perspective, what are our goals here? What do we want to come out of it? And I've listed quite a few here. And this whole PowerPoint is on the app and the website and stuff, so you guys can download it. But so what is important to your court? Because we first need to figure that out before we can go figure out what do we need to start measuring and what kind of information do we need to gather so that we have before and after statistics, right? So maybe your court wants to reduce default judgments. And maybe this is a tool that they think that's going to be the case. Well, we need to be measuring default judgments for a good period of time, and then we need to measure them again for a pretty good period of time, and we need to make sure those times match. So those are the kind of things that you need to think about. Maybe the caseload, this particular caseload has a 6-month time frame before a hearing can be held because there's so much backlog. Well, maybe that's what we want to do, is see how much faster we're able to get cases on the calendars, because we've been able to cancel a bunch of cases because they came to a resolution on their own. So really kind of looking through that and understanding it. And maybe it's just completely a PR perspective from the court. Hey, we're just trying to offer more online services, and this is one of them. And if that's the case, then we still want to measure it, but maybe, we're looking at different things. So once we've figured out why we want to do this, then we can start really putting together how we're going to do, the measuring. So our baselines, again, I talked a little bit about that, but we do surveys at the end of all of our processes. Obviously, it's optional, but we do the same survey for every type of case, no matter what jurisdiction it is, because so for all of our small claims cases, we have the exact same questions because we want to be able to compare jurisdiction to jurisdiction too. But maybe the questions are about the product and the usability of it. Maybe it's about the timeliness. I talked about that earlier, that one of the very first things that we got when we rolled out a pilot court last year in Las Vegas was that we were giving the parties 3 days to negotiate for a parenting plan. And they were like, we were so close. We could have finished this without needing a mediator or having to go to court, but we just didn't have enough time. So we've increased that to 5, and it's, made a drastic change. So again, just kind of making sure that we have the right questions in there and that we are asking them in a simple way. I know I have taken surveys before that you read the question and you're like, I have no idea what this question even means, right? It's so compounded that we don't even know what they're trying to get out of it. So make it simple, fast. I mean, if you have 20 questions, no one will answer it. This needs to be something that is, 5 questions, takes a minute or 2 minutes at the most to do. So think about that. And then we also do a lot of questions about the time and money savings. So how much time, did this take you, and giving them a range of options. And what do you see the benefits of this, and let them check any of those options there. Interviews. So you can do, person-to-person interviews with people that go through the process. So maybe someone that has successfully completed it and they did come to a resolution, reach out to them and see if they'd be willing to talk. And then maybe ask those exact same questions to someone who went through the process, but they were unsuccessful, and try to figure out what happened. Was it just that the parties couldn't come to an agreement, or was there something else that actually could be changed through the system? And then reporting, again, as you're taking what is important to the court and then you're comparing that to the results, you don't want to take a year segment on our disposition rate before ODR and then take a 2-week, measurement of what it's like after ODR. You're never going to get good results there, right? So you want to make sure that you have enough data, good sample, and that it's consistent between your before and your after pictures. And so just getting those prepared, a lot of times you can get that even after you've started the program, but at least if you have a perspective of understanding what it is you want out of that, you'll be better off. All right, so that was kind of the 4 steps to that. I think we are a little bit early. I do think the exhibit hall is open right now, though. So were there any other questions that came up that we didn't have time to answer? Anything else that you wanted to know specifically that we didn't address here that I could answer for you? Yes, sir.
Could you name 1 or 2 major roadblocks that you encountered when trying to implement ODR in your jurisdiction?
Okay, so name 1 or 2 roadblocks that we've encountered trying to implement ODR. I will tell you the biggest roadblock that we have had is mediators. The concern is that this whole process is supposed to be confidential. It's now online, written, and what's going to happen with, that communication after the fact? Is the court going to be able to see this, because the judge should never be able to see the negotiation that they've had? Those kind of things has been just a huge problem that we've really had to work. And that's why I say getting them involved in the beginning is so critical to being able to roll this out within a good time frame. I think the second thing on it is that the process is so new still in the court space. I mean, the idea of online dispute resolution has been in e-commerce for 10 plus years, but it's really brand new to the court space. So understanding what you want your results to be and having expectations that it's going to make it where, 80% of your cases are resolved this way and you only have 20% is probably not realistic in this, at least to start with. And so retraining people's expectations of, hey, at this point, if we got a 20% reduction in cases that went to court, that's a win, right? And then we just keep improving that until we get to, maybe it's half the cases. But I think those are probably some of the biggest obstacles that we've seen. Yes, ma'am.
So in thinking about where our court is hurting for a large urban court, we have hearing officers who are employees, and we're not utilizing this for traffic cases. People come in, they're angry right off the bat that they have to come downtown by parking. They are probably there for parking tickets to come in. But when we've looked into this in years past, we've learned that the system doesn't have the ability to go back into that case management system and pull all of the other hearing officers that that person might have parking tickets, so that we have the ability to work with them to create a package.
Sure.
And so has that changed in the last couple of years? Is that an integration of the system that we can pull based on a party system, all the other parking tickets that they might have in that jurisdiction?
Yeah. Do I need to repeat it? Okay. I didn't think that it worked. So the question is there the ability for integration for other cases like this, or maybe even other cases in general that the party has, to be able to see kind of a whole package and be able to prepare more than just resolving this one issue, but the whole party issue? I definitely think that that's the case. I mean, the integration is, we use standard integrations that are part of our ECF components for e-filing, and NCSC has now started to come out with ODR standard components, and so we're in the process of working through and making sure those are there, implemented. So I think there's nothing that's stopping that integration from being available.
But it hasn't been built?
No.
Anywhere else yet?
Right.
Okay.
Mm-hmm. Yes.
Ever do it more than two parties?
That is really a very big question that we at least have yet to figure out the right way to do this, because anytime we talk to a jurisdiction and we say, like, let's kind of talk about a small claims case, and we say, okay, there's one plaintiff and there's two defendants. What if one defendant agrees to the terms but the other defendant doesn't? What happens? And usually we kind of get blank stares back, because I don't think there's necessarily, when they go to court, there's a step-by-step process that fits every scenario. And so until we kind of get a definition of how that works per jurisdiction, that's something for us that we have kind of set aside. But the system will allow it. It's just we need to understand, is it the joint and several process where as long as the person gets paid, it doesn't matter who's paying it, or can one party agree to everything, all of that.
Have you tried this with any, child abuse mediations?
Not yet, we have not. Yes, sir.
Excuse me, you mentioned about rolling it out in Las Vegas for parenting plans. You gave 3 days, and then they said if there were 2 more days, maybe they would reach agreement. And you said something about mediators. Did you say there weren't mediators involved in the first 3 days?
That's correct. Right. So the way that it works in Clark County is, in that 3 and 5 days is just the initial start of it. It's not the whole thing. It's just for one party to get started and propose a parenting plan. So the way that it works there is that the first party has 5 days to come up and propose a plan. Once they propose that, it then is sent to the respondent to review that proposed plan and either agree to the terms or propose something different. And it's term by term. I mean, it's not like they don't have to look at the whole plan and say, I agree with it or I don't. They can say, okay, for legal custody, no, I think we should have joint custody, but for all the rest of them, I'm good. And then it would go back to the plaintiff to review anything that they didn't agree on. And they have like an 18-day period in which they can do that back and forth before they have to have a mediator. But at some point after that 18-day, they can either request mediation at any time, or after that, I believe it's 18-day period, they are required, like a mediator gets assigned to the case.
And do you have any figures as to what the parties agree on a plan?
Yeah, we do. So if both parties engage in the process, right now I think the 10-month numbers is that 35% of them agreed to a full parenting plan without mediator assistance or coming to court. So more than a third of the parties were able to come to a resolution and create a plan that was then sent to the judges. It actually, that's the case type we started with, and I was a little gun shy. I thought, why on earth are we starting with the hardest case? We take contested divorce with children and start there because, most of the times, sadly, the children are a little bit of a pawn in that process, right? But the results have been very positive in the resolutions that we've seen, and they average resolution in about 6 days. So the parties come to a complete agreement in 6 days. The fastest one that we've had is like a day and a half where they've come to resolve it. Yes, sir.
Have you done any custody visitation mediations where there's domestic violence involved?
So I was actually not aware of this because normally in a mediation, the question was, have you done any with domestic violence? Normally when we're talking in mediation, they say those are excluded and we want to make sure that those are done in person. But I actually found out recently that in Las Vegas, they're not excluding them. So I don't know any numbers of which ones of the cases have any domestic violence accusations on them, but I know some of them do. But I don't know if they've successfully resolved or not because I'm not sure which cases it is. And honestly, I go back and forth because I can see, again, pros and cons of domestic violence. But the thought of being able to be kind of protected, you're behind your computer, you're not face-to-face with that person, I think that would give you a little bit more ability to speak your mind. But, maybe not. Maybe the accusations that they're saying to you and the things that they're doing still are the same as if you're in person to person. So I don't really have any training on that, so I'm not sure. Any other questions? Well, at the exhibit hall, Stephanie is over there, and she'll be happy to show what this process looks like, so you can actually see it in action if you've never seen it. And if you have any more questions, we will be happy to answer them. So thank you all for your time this morning. Mm-hmm.